He be in? Joining me now to help answer this question is legal expert Paul Deranassian. Thank you very much for joining us.
Good to see you, Liz.
Okay, this looks very bad to me, and I'm not an attorney, of course, but it seems to me that we're coming down, if David Soares decides to pick up the ball, to perjury charges.
I think you're right. It is very bad. You have a retired chief judge of the Court of Appeals laying out the facts that would support a perjury charge. It's certainly not a politically motivated report, and again, it's backed up. And as you point out, it really winds up to what is the Albany County DA going to do? He has discretion in this area. It's really his call at this point.
Now, actually, the AG's office could have picked this one up. I mean, she could have said, because the governor had actually empowered the Attorney General's office, correct, by asking the Attorney General's office to do this, and then Andrew Cuomo at the time thought he might actually have to run against David Paterson. That's how Judith Kaye got involved to begin with. But they could have brought charges. Why do you think they did not?
They could have, but I think for the reason that you said. At one point it seemed as though Cuomo might be in a primary against the governor, seemed best to hand it out. And ordinarily, these types of charges would be primarily in the jurisdiction of the Albany County DA.
Right. But in addition, isn't it true that these things, I mean, how long might this last? It could drag on for some time. Troopergate, I mean, we just saw Darren Dopp, the former communications director for Eliot Spitzer. He paid a $10,000 fine this summer for a scandal that broke over 2 years ago already. So what is the timing of this sort of thing, generally speaking?
There is none. And I think you're right. There's no limit. That's the problem. That's the point. Now, this actually went pretty quickly, this investigation. I think this is a very quick investigation, and the idea that we have it within months, I think, is very positive, because quite often these things can take years. If you look at other political types of investigations, whether it's Scooter Libby or Governor Blagojevich, who was also convicted of making a false statement, that's the only thing he was convicted of, these things can take years sometimes.
Well, let's look at a couple of just quotes coming out of this report, because, as Caitlin noted earlier, it was very carefully worded. Now, the first one talks about the Commission's request that the Attorney General's office investigate false testimony. This is basically lying. That's what we're talking about here. And it regards the governor saying that he had always intended to pay for these tickets. And the Chief Judge said, no.
The Chief Judge points out there's many indications there was no discussion beforehand. No one testified there was any evidence that there was an intent to pay, just the opposite. And that's the core of the perjury charge. The governor stating that he intended to pay for all these tickets when it appears as though that was changed later. And one of the things she puts in her report is, gee, for the first time at a certain point the governor made this assertion. There was no evidence of that before that. So that's the core of the perjury charge that the Chief Judge says may be possible in this case.
And I'm sorry, what kind of penalty does perjury carry?
Well, felony perjury carries a punishment of up to 7 years. Now, first offenders may not get that, but then you have to look at it, would a felony conviction affect this governor? And the answer is he's not even a practicing attorney. He's not a licensed attorney, never passed the bar. So he doesn't have that exposure that, let's say, Bill Clinton did, who actually was convicted of perjury for lying at a deposition.
Well,
but he did not have to worry about a loss of income in any way.
But no one wants that. I mean, you know, it's certainly not. It's not going to cost him his job. I understand that. Not going to cost him his legal license. That's the problem. But the man has to get a job after he leaves, because he's not running for office. I mean, a perjury charge, how serious is that if it's on someone's record and then they go to get a job in the private sector?
I think it depends on how good your other skills are. And I think Bill Clinton's a good example. It hasn't affected him whatsoever. For other individuals, it has affected them. Certainly would not affect his ability to practice law. I think many of his problems and issues surround this and other things that have occurred more than really the idea that there's a consequence to him from a perjury charge. But again, you made another important point. Prosecutors quite often will say, and you saw it even in the Bill Clinton case, you saw it with Richard Nixon, don't want to put the public through this. And we talked about the last time I was here. Quite often prosecutors will say, is it worth putting the public through this type of agony? Let's move forward. And actually, that's well within the discretion of a prosecutor to think like that.
Well, and particularly in New York, when the public has been battered by so many cases. I mean, you had Eliot Spitzer, you had the Troopergate case that we referenced at the top of the show, and then from there you had the prostitution scandal, and from there you had the Governor Paterson's own scandals, now multiple heaping up of them, some of them resulting in charges, as Caitlin mentioned, some of them not resulting in charges or accusations of charges, we should say. He's not technically facing anything at the moment. But So let's come up with this other second quote, because it's actually very telling. There were a number of things that the Attorney General asked the Chief Judge to look at. And the first was whether or not the governor had lied about his intention to pay. The second one was regarding forgery. And she did not believe that there should be any criminal charges brought in this particular case.
And that had to do with a check. The check appears to have been indicated to have been written before a particular date and time. But one of the things she points out is there was no clear proof as to when that check was written or produced. Memories weren't clear on that point. And more importantly, the letter that submitted that check, which may have been a backdated check, seemed to indicate that people were not trying to hide the fact that the check was prepared or at least being submitted after the event in question. And I agree, that makes it a much more difficult case criminally. But ordinarily, a backdated check, again, could be some evidence or indication that he lied about when he intended to pay.
Now, the governor, as we know, is visually impaired. He is not able to see. This check and then the cover letter that accompanied it appears to have prepared by David Johnson, who is one of the aides who is involved in this scandal, also involved in the domestic violence scandal. And so the fact that he prepared the check, does that matter in this instance, that it was not the governor himself?
Sure. I think that's one of the things from a defense point of view that's going to be helpful, that he wasn't involved in preparing it. But related to that, there's a reference here to that these exhibits appear to have been reviewed by the governor before he testified. And there's a footnote in the report about the attorneys and going over the documents with the governor, but that it wasn't recorded. And I think that's one of the reasons the judge put that in the report, to show that the governor did have some prior knowledge about these documents before he testified, even if he wasn't involved in their preparation.
Now, one other sort of sticky wicket here is that David Johnson, who we've just mentioned, this aide, is now, right now, facing charges of 5 misdemeanor counts of assault. He's got a case going on. And now how will that affect this case as it goes forward? I mean, could you get one person, the Bronx DA is handling it, to flip on another person if a case is being handled by the Albany DA, or are they just completely on separate tracks and they have nothing to do with one another at all?
It can be either way, and certainly in many cases people are, as you say, flipped for that. Pressure is put on them to try to cooperate in another matter or to avoid punishment. What do you need to know about this other matter? And they can try to use that. They can also, if pressed, if subpoenaed by a DA, assert their Fifth Amendment rights and not testify. And you also note that in this report, the judge pointed out that his counsel did not testify. He asserted the attorney-client privilege, but she also suggests, well, maybe the DA in Albany will pursue that further as to whether or not that's justified. Maybe there is no privilege. So you can see there's still some options here, whether it's calling the witnesses that you mentioned or even with the counsel.
Just very quickly, this last quote, I just am sort of flummoxed by it. What does it mean when it says that the governor's opportunity to avail himself of the affirmative defense closed? What is that about?
I think it's very interesting. Once again, the Chief Judge points out that if for a perjury charge, it's a complete defense that you say, wait a minute, I made a mistake, and you do it before it affects the proceeding. In other words, before the trial is over, before the hearing is over, or the investigation. So what she's pointing out is he was given an opportunity to correct this testimony. He didn't. And to me, that's an aggravating factor that points the finger toward a perjury charge when she's saying, look, he had this opportunity, he was aware of the problem, he did nothing about it. That would go to his intent.
Well, this is clearly going to be going on for some time, and I'm sure that you will be back to speak with us about it, Paul Derenesi. And I want to thank you very much for trying to make some sense of 41 pages of legalese. Thank you very much.
My
I
pleasure.
appreciate it. We are